Thank you, and thank you, Minister, for being here today. You're always very welcome. The WRC and indeed the Labour Court are to be absolutely commended. I think that they are a fantastic body who, in their previous guise as the Labour Relations Commission, have done a fantastic job and are certainly there as the barrier to stopping poor employment practices and outing the abuse of employees. So they do a fantastic job. And I think that I really welcome this decision of the Supreme Court and of our quick response to it, because I think it emboldens and widens the scope and strengthens the powers of the WRC in doing so. The fact that evidence would need to be given on oath and that it is heard in public, I think will do an even greater service to the operations of the WRC. I think that it has been said, and I've often quoted it myself in submissions over the years, that it has been said in the High Court that next to losing your liberty, the worst thing that can happen to you is losing your job, because of all the financial consequences that flow and are dependent on our income. So the idea that once somebody gets before the WRC and has to go through that unfair dismissals, that evidence needs to be on oath. It needs to be in public. And my own experience of it from an employer's point of view and an employee's point of view would be to see that the same repeat offenders of employers are in there again and again and again, and there are some really big names that should just have bunk beds in the corner, as I've said here before, because they are repeatedly in there. There is never a day when you go down there that that same name isn't up on the screen. And so I think that pattern, that ability to report and name names will be a very important feature. And I think actually, in my own view, it was regrettable that wasn't in from the very beginning when we brought in the WRC Act in 2015. I think from an employee's point of view, yes, I can understand the sensitivities, and I know the nervousness as I've sat beside people, both instructed and in pro bono cases, of the fear of the process, the fear of... and employment law, I think, can be underestimated as to how complex at times it can be. And though the WRC is there to be accessible, it does require, legal and experienced union personnel, and I've gone in as both over the years. But I think that there can be sensitive content on the part of the employee, so being able to make a submission to have the matter anonymised or in private will be very important, and it is important that the adjudicator can operate in their own regard. I think another element of this would be there are solicitors practising in the country who put in vexatious, spurious claims and throw the sink at on behalf of a person making a rather vague claim, and an employer can find themselves on the wrong end of, in one instance I was briefed for 147 claims, where we could produce timesheets, we could produce everything, but this kind of vexatious level, and I think there are repeat offenders amongst the legal practitioners as well who are guilty of that. So this may expose them also. A feature I think that does need to be addressed, though, however, is that lack of a predetermination of a prima facie case. And that lack of having preliminary matters dealt with before you're actually hearing the whole matter. I think that lends itself to clogging up the system. The fact that you can sit there and argue a preliminary matter that there is no jurisdiction, and then still have to go through the case just in case they find that there is jurisdiction. I think there are things, something along the lines of the Masters Court for the High Court or the County Reg for the Circuit Court that could be put in place that would unclog the system, that there is a better system for adjudicating whether actually we should go to hearing. We shouldn't go to hearing on absolutely everything, because some things either shouldn't be defended because they're so blatant, or and then they should go to hearing and we go on that. But some things don't even reach the bar of prima facie. So I think that is something. The removal of adjudicators, hopefully it's very rare. I have had the experience of going in and the other side handing a birthday card to the to the adjudicator. Unfortunately, I was robust enough to argue it, but if that person was there on their own, without counsel, without a representative, they wouldn't necessarily know how to handle such a matter. So I think that is certainly to be applauded, that there is this sense of complaint and transparency, I suppose. So I certainly commend this legislation, and thank you.
Thank you, Senator.